Alrighty, good morning, everybody. Thank you so much for joining us for another webinar. We are very privileged today to have a couple of friends from the industry. We've got Willie and Mike and Reghard, and today we're going to have a little bit of a higher level conversation about proprietary rights of ownership. If any of you have heard that terminology before, I remember it takes me back to my university days where we were taught. Nicole, Nell, and Sarah in front row remind me that we have a quiver of rights. Imagine a quiver of arrows, and if you take some out, you have limited rights, and if you fill it up, it's your full rights of ownership. Reghard, you studied with me. I'm sure that I got that completely wrong, and Prof. Van der Walt would be very unhappy to hear that. But I seem to remember something along those lines. So before we get started, we'd like to just give you a couple of announcements, and then I'll do a little bit of an intro to our speakers today, and then we'll get started on the topic. And if you have any questions, you're more than welcome to pop it into the chat. If you have any comments, otherwise you're welcome to put your hand up, unmute, and we can have a bit of a chat. Yeah, Carl, over to you.
Thanks, Zerlinda. Good morning, everyone. I hope you're all doing well, and thank you so much for tuning in this morning. Just a few marketing announcements, as Zerlinda mentioned. This webinar is being recorded and will be published on our website as well as our YouTube channel. And if you are subscribed to our newsletter, then the recording will be emailed to you. And then our neighborhood live discussion will happen Friday, the 28th of November at 9 a.m. Please note that this feature is only available to paid for members. So if you'd like to upgrade your current package, please reach out to me. Yeah, that's all the announcements I have for today. I'll share all the relevant links in the chat. Thank you.
Fantastic. All right, let's start with an introduction to Willie. So Willie has practiced as a property attorney for more than 20 years. He was involved in sectional title management for his sins for over 8 years, and has dealt with various municipal issues and interacted extensively with local municipalities. He started Stratafin in 2014 with the goal of assisting bodies corporates with their funding without catching them. This is my favorite term ever, the debt trap. And for those of you that don't know what a debt trap is, I'll ask Willie to explain it. I think of it on the context of paying your groceries with your credit card. That's what I took from that, Willie. So Stratafin strives to be a fair and equitable money provider for the sectional title industry. We can most certainly recommend them. Mike Addison completed his schooling at Pinelands High School right here in Cape Town before he went on to pursue an associate's degree in banking and finance. He kick-started off his career with Barclays Bank in 1979 and started his way up the corporate ladder, sorry. He went very, very far. He now specializes in sectional title insurance and has been doing this for 25 years. I see that Bruce and Candace from Addsure are online as well. Welcome, guys. Mike founded Addsure in 1995 and soon began to focus on the community schemes arena, noticing a gap in this particular market in the industry. Addsure is a nationwide business with offices in Johannesburg, Durban, Port Shepstone, and its head office right here in Cape Town. Addsure are very well known in the industry. We can most certainly agree with their expertise and thought leadership in the community scheme risk and insurance environment. Reghard. So I mentioned that Reghard studied with me at good old Stellenbosch University, and he has gone on to achieve amazing things in his career. Reghard Brits is an attorney and conveyancer at Brits, Dreyer Inc. in Bellville. He holds the degrees BCom Law that he obtained in 2007, LLB in 2009, and his LLD in 2012 from Stellenbosch University. After completing his doctorate, he was a postdoctoral researcher, also where I was at the South African Research Chair in Property Law at Stellenbosch University from 2013 to 2015. And then from 2016 to 2021, he was a senior lecturer and associate professor at the University of Pretoria, after which he left his full-time academia for legal practice. However, he remains involved in academia part-time and is an extraordinary professor in all sense of the word, Reghard, at the University of the Western Cape and a research fellow at the Stellenbosch University. His research focuses on real security rights, which we're going to be talking about extensively today, as well as general property law, insolvency, and consumer credit law. Very interesting, heavily. He's the author of Real Security Law, a Jutta publication from 2016, as well as the co-author of the 6th edition of Silberberg and Schoeman's The Law of Property through LexisNexis in 2019. That's like this massive textbook, this thick, that I carried around everywhere with me for property law when I studied at university. So really, really fantastic to be a co-author of that. Welcome, everybody. Thank you so much for joining us. Have had quite a few questions in our consulting practice and in various webinars and events that we've gone to about ownership when it comes to all forms of installations, not just solar. Everything from DSTV dishes to chimneys to awnings and everything in between. And whenever we get this type of question, the first thing that we ask is, what is the legal nature of the area in which the installation is being made? And of course, a lot of these installations in its nature has to be installed outside, and more than 99.9% of the time, the outside that it's being installed on is, in a sectional title context, common property. And of course, we know the common property is owned by the body corporate. All the members of the body corporate own the common property in undivided shares. So you can't say this piece of roof is mine unless you go the extension of a section route or an exclusive use area. It goes further, and we could perhaps enter into lease agreements, we could enter into servitudes, and with that comes a whole bundle of issues. I think I'd like to start off with Mike first, because I know something that I'm constantly telling people in our consulting practice when it comes to solar installation, but I think it extends to all installations, and Mike, you can correct me if I'm wrong, is that there has to be formalization one way or another to actually have this installation, as well as the area of common property upon which it's going to be installed, insured. And of course, that's vitally important. And you told me a little while ago that other than the damage that is caused by weather and all those fun things, it's even possible for installations like solar to be stolen. So insurance has a role to play there. Mike, can I hand over to you?
Yeah, the insurance is actually the easy part. First of all, good morning, everybody. Really great to be here. Um, yeah, the insurance part is really the easy part. It's everything that leads up to the putting it on cover, which is the more technical and difficult part. But insurance, and just by the way, things change, almost from month to month. There's now some more relief with the insurance. So we're back to 2 years ago. Not too many forms needed by the main insurance players these days anymore, as of about 2 weeks ago. So latest news for everybody is one of the main insurers has relaxed the requirements with all those forms. Okay, so that's actually quite a nice thing. So when I say back to 2 years ago, let's start at this point. Um, when you're insuring solar panels on the roof, it's treated as part of the building. I'm sure that's where we're going to go drilling down into just now with Reghard, where he's given us some inputs into this. But what I normally do is I try to ascertain whether um, what we are insuring, whether it's a fixture or whether it's movable. I think that's for an insurance broker, that's step one. The legal guys look at things a little bit differently, but from our point of view as an insurance broker, we want to know whether we must treat it as part of the building for insurance purposes, or whether the movable item, in other words, this thing is on wheels, whatever it is, it's going to be moved out with you when you move, it's taken away, it hasn't acceded to the common property, then that item needs to be insured in a different way with your household contents or something else. But that's step one. Once we've ascertained that it's immovable property, then we need to understand whether it now accedes to the common property. I'm going to leave that for you guys to discuss just now on when it accedes to the common property and when it becomes part of the building. And then thereafter, we decide on how we're going to insure it. Are we just going to treat it as part of the building? Now, when we treat it as part of the building, we're saying that we're going to cover it for normal perils. What do we mean by normal perils? Fire, storm, wind, hail, sometimes snow, etc. And fire, of course, but those would be normal perils. But if you want to extend the perils to theft or power surge, then one needs to insure it more comprehensively. Well, let's call it more in a specified manner. So we'd put it on an all risks basis, and then you would pay a higher premium, and then you can cover it for theft. In the normal sectional title environment, we haven't really seen that need. I'm talking about in the residential environment. Um, although theft is occurring, it can otherwise get expensive. You can imagine to put something on cover at a rate of 5% per annum can be rather onerous, especially when you've already got all of your security in place. But it is something to consider, because one day, if it does get stolen and the trustees didn't do it, then the question is, why not? So, yeah, always go through the process of asking. Yeah, I think I'll leave it there for the moment. Back to you, Zerlinda.
Fantastic. Reghard, can we hand over to you to chat a bit more about the rights of security or the rights of ownership when it comes to these types of installations? And we don't have to be limited to solar. We can look at any form of installation when it's placed on common property that is co-owned. And then perhaps chat a bit about these, and I'll ask Willie to chat about it as well, when these types of installations are not necessarily owned by the individual that is installing it either. So if I can hand over to the two of you.
Yes, thank you very much, Zerlinda. Good morning, everyone. Thank you for the opportunity to talk a little bit this morning. So I think what I'm just briefly going to discuss is ownership of these types of installations, and also why it matters, and then just a couple of words on how to determine who owns the solar panel. I mean, I'm sure everyone can imagine that it's an important question to ask. It may seem obvious to many people that the person who buys it owns it, or something like that. But from a legal perspective, it can be far more complicated, and with regard to any type of installation. So especially the ones that are more modern, that are not that are kind of unique sometimes to some buildings, it's not always easy to know whether the object forms part of the building or remains like furniture, basically. So that's where the issue comes in. And the reason why it's potentially a problem is that the owner of the building is always automatically also the owner of everything that is permanently attached to that building, that has become a fixture or an accessory of that building. So if something is permanently fixed to a building, then it can't be owned separately anymore. And that, as I'm sure you can imagine, could cause problems, especially if the solar panels were originally owned by someone other than the owner of the building. And that's when the popo hits the fan. And in the sectional title context, there's an extra layer of complexity, because the common property to which these things will almost always be attached belongs to the body corporate, and not even to the section owner or the unit owner. And I think this could cause a lot of confusion out there, because I don't think many people understand this idea, especially with sectional titles where it's like a little house. And many people would assume that whatever you put on the roof is also yours because the roof is yours. That's how they think about it. But technically, we know that is not the case. So the outside of the building and the roof belongs to the body corporate as a whole. So that adds a tricky dimension to this, because if the consequence is that you lose ownership of your solar panels, or even your air conditioning unit, or cameras that you put up outside, or your DSTV dish, or whatever thing you put up outside, if you lose ownership of it and the body corporate becomes the owner, then I mean, obviously that's going to it's an odd concept, and it's obviously going to cause problems, and that's not what you want. So you don't necessarily want to lose ownership of your solar panels, but it might be the invariably the consequence. So that is why this could cause a problem in practice. And just to give you a bit of an example also, if you think about it from the perspective of buying property, buying or selling, if you go and look at the new sectional title unit you want to buy, there's solar panels on the roof. Do you expect to get that also when you buy the unit? Or do you understand, or is it part of the furniture that the current owner potentially could take with him? So things like that could be a problem, especially if you expected the solar panels to be there, and the day you take occupation, they are not there anymore. They left with the moving van the previous day.
Yeah.
Even the body corporate might not even know, or there might be all sorts of issues. So you can imagine that could be a big problem. The same if you sell your property. Can I take my solar panels with me, or must I leave them there? A big room for conflict, especially if you want to take them, but the body corporate says, no, it belongs to us now. And the new buyer obviously is also there in the middle, also wants it. it to remain there. So it can be quite tricky. The partial solution to that is to specify it in the contract. So make sure that everyone is on the same page on what's going on, and obviously have communication with the body corporate on the installation right from the beginning, hopefully. But I'm sure we will speak about that also. So the question then is, when are these types of installations part of the building and when not? And this is one of those topics that we can speak about for 5 hours and still not get to the answer. In fact, the more you think about it, the more difficult it gets. It may seem obvious and simple, but even if you look at the case law and how people have, before the courts, argued about whether certain things form part of the building or not, then you can see it gets quite complicated and messy quite quickly. And we don't have any cases thus far on solar panels specifically, but we have many other cases on many other different things. So there are many examples going on out there. But ultimately, what the court is supposed to do when a court is faced with a question like that is to look at all the facts of the situation, and they will look at certain factors and then supposed to make a decision on whether this object has become part of the building or has remained movable. So just to briefly mention the three factors. The first one is the nature of the object and the purpose of the object. So is this a type of object that would normally form part of a building, or is this a type of object that would normally be a piece of furniture? Like, is it like a chair, or is it like something that becomes part of the fabric of the building? Secondly, how is it attached? So that's a technical aspect of literally what method is used and what materials are used to attach it to the building. And does that indicate that this is a piece of furniture or a part of the building? And the way the courts deal with this is usually to ask whether it can be removed without causing damage. So in practice, this is actually not a very useful test because practically everything can be removed without causing damage. So it doesn't actually tell you anything, but the courts tend to focus on it quite a bit. So even though practically it doesn't really tell you anything. And to give you a silly example, the windows of a house can be removed. The doors of a house can be removed. But no one in their right mind would think that the doors can be removed. If you buy a house that you move in, the doors will be missing. No, no one thinks like that. I think most of us will realize that common sense tells us the doors are part of the house. The windows are part of the house. And this actually, before I could go back to that point, let me just mention the third factor. So the third factor is the intention of the person who attached it, the installation, or also the intention of the original owner who attached it. So, but just to get back to the common sense point, I think when dealing with these situations, it's very difficult to find an answer purely based on the technicalities of the situation, because it can take you in any direction and it's very difficult. It doesn't really give you an answer. But ultimately, the answer really is in common sense. How do members of society think about these things? How do they think about doors? How do they think about windows? How do they think about the roof tiles? The answer doesn't always lie in what the technical engineering aspects of it is. Can it be removed or not? Because you can remove anything. Most of the time it'll be a common sense question. Is this the type of thing that normal people in society will regard as part of a building or not? Normal people will see the door as part of the building, even though it can be removed. Normal people will probably see the geyser, the electrical geyser, as part of the building and not as a furniture, even though it technically can be removed without causing damage. So ultimately, I think the answer to things like solar panels will lie in how does society view these things? Are they part of the building or not? So my personal opinion is that we are probably heading in the direction of them actually being part of the building. So it's very debatable. There are many arguments in different directions, but my sense is that, especially as time goes by, we will see solar panels as an ordinary part of a building. In the same way that we look at the air conditioning unit or the electrical fences and the alarm systems and the cameras and the geysers, for example. I think solar panels are very similar to geysers in that sense. But Yes, so I think that's my general sense that it will, in most ordinary situations, form part of the building. There may be exceptional circumstances depending on what's going on. And um, there are two, I just finally just mentioned there are two situations, and I think we'll probably speak about this in a bit more detail, the others too. There are two situations that kind of override everything that I just said. And that is in the case of a tenant. So if a tenant installs something in a building, there's a presumption that it is not done permanently. So the object that is installed will not become part of the building. That is an assumption that the courts have also established. And the second one is that if the installation is owned by a credit provider that has financed it, then the courts are very, very likely to regard it as a movable thing that did not become part of the building, usually for commercial reasons and because of the importance of credit provision and so on. So these are the kind of two exceptions that would often override what your common sense would tell you about whether something is part of a building or not. But I think I'm going to leave it there for now. If there are any other further questions, then obviously we can continue speaking. But I think that's enough for now. Thanks.
Fantastic. I particularly enjoyed the comments about, when you're getting ready to sell your place, rather take everything that you want to take with you off before you start marketing it. Because when somebody has that impression of this is what they're going to get, and then suddenly it's not there. And I
Or at least
remember,
disclose to them that you are not going, this is not included. Make sure they
correct,
know.
correct. Yeah, like that little form, that additional information, like I'm taking my blinds with me or my chandelier or whatever it might be. Yeah. There was a case, Reghard, or maybe it was just an example that our lecturers used at the time, but bar chairs with like a built-in kitchen counter. That was also something. I think it's when the movable item cannot be used, excluding the immovable, or the immovable can't be used without the movable, or something. The movable was considered to be part of the immovable. I thought that was interesting. And I think from a solar installation, it also comes down to the pipes, wires, cables, and ducts, and maybe the inverters and all those fun things, the batteries, all those things that are associated with the solar, because we know that we can't just, prop some solar panels on the roof and then expect it to work. There's connections and things that come with it, but those will then be inside the section as opposed to on common property. So also something to think about. Super interesting, hey? Willie, from a ownership and a financing and all those perspectives, I know that you are the stellar when it comes to research and opinions and debate. Let's hear your input.
So, Zerlinda, thank you for the opportunity to form part of this discussion this morning. You've actually mentioned quite a few things that I also wanted to touch on, and the bar stools is one of the examples that I also wanted to use, and because it serves the bar. So therefore, it forms part of the bar because it serves the bar. And the solar panels serves the inverter and serves the battery and serves the installation. So from that point of view, one can probably argue, therefore, that even if you can remove the panels easily, because they serve the rest of the installation, as such, they form part of that installation. So agree with that thought of yours as well, like we generally do agree on these types of things. And as Reghard says, it is not necessarily how it is affixed that gives us the answer, because we've also seen in respect of a matter, and now I'm opening the drawers that open slowly because of time. When I was at second year varsity, there was a case in respect of irrigation piping in Stellenbosch, if I remember correctly, the matter on one of the wine farms that was trenched and then it was placed under the ground and then filled again. And so therefore they were part of the land now. And the court actually held that in those instances, because it could still be removed and the intent always was to remove it, that it was movable. So very difficult concept to understand sometimes, and sometimes the courts come up with very weird decisions in that regard. Then regarding ownership in general, when you finance something, ownership is retained by the person that finances it as part of the security in respect of that matter, and ownership only goes over once you have paid the full payment price, and then it's delivered by the shorthand, if I remember correctly. My studies in that regard. So you already have possession, but possession is then given to you by the fact that you make your last payment, and then ownership at that moment goes over. And where ownership is retained and somebody else have ownership, then those rights are vesting in somebody else, and one cannot transfer rights that you don't normally have. So if you don't have a right, then it's not possible to transfer rights that you don't have. So if I'm a tenant, I can't go and sell my landlord's property and give ownership to somebody else, because I don't have those rights to pass on to somebody else. So in general, the finance company would retain ownership, and that ownership then is protected from a commercial point of view, because otherwise banks and finance businesses won't actually finance these things. But we've also now seen in the industry that solar installations, because they are quite expensive and people can't necessarily afford them, that they are now rented. So we are now seeing that companies install these solar installations on the roofs, and they remain that company's property. And the person that receives the benefit is then paying a monthly rental in respect of that. And if that person then vacates the section, and the new owner of the section does not want to rent it, then obviously the intent was always that this is movable, and therefore it was a rental agreement, and therefore they will be entitled to remove their equipment, or so we hope, until we see the courts find in a different way. So it's a very interesting subject, and yeah, we'll still see. Our eyes are open to start seeing the litigation in this regard.
I can't wait. Mike, to chat about something different to solar, but still in insulation. Back in the day, there was a scenario where somebody had installed or built in a swimming pool on common property, and they were shocked that suddenly it became, the property of the body corporates and everybody could use it. And then when it comes from an exclusive use area, it's obviously exclusive use still being in its nature common property, we always need to ensure that from an insurance perspective, all the national regulations and all those fun things are complied with from an insurance perspective. But could you give us some interesting stories about some other forms of installations that you've dealt with from an insurance perspective, which has resulted in the owner or the body corporate having a bit of a like what the heck moment?
Yeah, I didn't prepare, so I have to dig into the memory cells. But swimming pools are the main one, and that's why I rather like the idea of, when you're installing solar, to look at an exclusive use area, because it ticks a few insurance boxes. So almost from it's the insurance obviously being my patch. I like to tick the boxes in the insurance part, and that's why I lean towards exclusive use area as my favorite way of dealing with solar. Now, non-insurance people or attorneys that don't deal with insurance will have a different leaning, probably. They might lean towards other ways of structuring. But the reason I like it is because I do liken it to a swimming pool, for example. And it speaks to what Reghard was saying just now. Somebody sticks in a swimming pool in their garden. So first of all, is it really their garden? Has an exclusive use area or been, set up? Has it been created in terms of the rules? If it's not, the stack, the corrected old-fashioned way. And if it hasn't been created in the rules, then whose swimming pool is it? They drop in the swimming pool, they spend a couple of R100,000. It automatically becomes the body corporate swimming pool, probably. And the problems really arise later. All very well when everything's new and everybody's happy, but 5 years down the line, especially if it's cracking or if it's a fiberglass that's starting to peel off, who must fix this? You know, you can sign 10 agreements with the owner when he installs it, but if a new owner comes in 5 years later and buys the place with the swimming pool, he's not burdened with that agreement necessarily. He didn't even know about that agreement. Where is it in the rules? He's going to turn around and say, well, body corporate, it's common property, fix it. Um, and these sort of things, it usually starts off with Mike, is this an insurance claim? So that's why we see a lot of these horrible situations. So I always say, it's so important to get these things right. When we go to a building, one of the first things we ask is this exclusive use areas? Are these garages exclusive use areas? Garages are the other one. Clive's on board this morning. Clive's got an interesting one. We've got a scheme. I think it's Clive. I can't remember off the top of my head, but there's 30 units out there, and it's got mostly section garages except for one. One's an exclusive use area garage. Now, in fact, I don't think it's even an exclusive use area garage. It's just common property. So, you have what you call de facto exclusive use areas, and so on and so on. So what we do is we try and treat the solar panels as de facto exclusive use areas, even though they're not. Nobody's even mentioned the word exclusive use area, but we structure the policy as if it's a de facto exclusive use area, because it's quite interesting. As Reghard has said, that fixture, for all intents and purposes, I treat it as, unless it's rented or financed, I treat it as, no, that solar panel now is part of the building and it's part of the common property. It is serving Section 1, and Section 1, paid 50,000 Rand for those panels. So how does that owner, how do we deal with it when it comes to the schedule of replacement values, for example? Because on the schedule of replacement values now, you've actually got to place those panels somewhere. If you place it as the additional sum on the section, then you're saying, as the body corporate, we're treating this as part of your section. Now, technically, that's incorrect. So what we do is we place it on the common property as a line item, and we say, those panels are not in your section, they're on common property, but we're going to treat it as a de facto exclusive use area. So we're still going to want 10 Rand a month from you, or whatever the case might be, for the exclusive use, or we're going to charge you an exclusive use area contribution. And then the batteries and the inverter, that portion might be 80,000 or 100,000 Rand. We'll add that to the additional sum because that's inside your section, or we won't. We'll just treat it as part of your section. Okay, so yeah, those are the two. Those are probably the two issues that arise when it comes to funny things. I don't know if that's answered the question. Funny
Yes.
things. I think air conditioning units are common. Yeah, fights over air conditioning units is probably the common one.
Time, hey? Yeah.
But swimming pools.
I think you told me about the theft of solar, and you also told me, I think, about the theft of downpipes on common property, or connections to downpipes or something like that, unless I'm smoking my socks.
No, we've had all sorts of things. I can't remember all of them. We've had a flagpole gone, stolen. So a huge big flagpole got stolen. Live pipes get stolen. So yes, they definitely get stolen. We've got some stories about those pipes that just get ripped off the building and it leaves fountains. Table View, Sea Point, we've seen a lot of those. Seems to be the Bergies with their toolboxes go around. So yeah, it's another whole long story. I've mentioned it before, but when I went overseas to Australia once, and I met with insurers in Perth, and we were sitting in their office, and we were comparing notes. They couldn't believe that we actually had that people actually are steel pipes off buildings. They couldn't believe that we even covered that sort of thing. Is that really necessary? I mean, does that actually happen?
Welcome to
Yeah, so it is interesting. We are unique in some ways. I think that was one of the stories. And yeah, theft of solar panels, it does happen. So I would mention that if you're in the commercial area, so if you're a commercial building, say in Montague Gardens somewhere, or up here, in Johannesburg, in one of the industrial areas, and you've got solar on your roof, I would definitely insure it for theft. You pay your 5%, but or 3% or whatever you can negotiate. But you've got to weigh it up. But I think the key is disclosure. Clive Reynolds, again, compliment. He really puts out information. In fact, I've actually noted a link that you might want to. Clive said I could mention that we could share it to everybody, a whole brochure on solar panels on how to deal with it. If you want me to put it on the chat, I will just now.
Thank you so much, Mike.
But the Clive actually asks all the right questions, and I think that's important. You're putting a solar panel on. Do you want it covered for theft? I think that's the big question. If you deal with that question, then as a managing agent, because obviously there's a lot of managing agents here this morning and trustees, but from a managing agent's point of view, if you ask that question, you're already covering yourself. Nobody can come back to you later and say, why didn't you tell me that I should have covered it for theft?
Definitely. Mike, you can take a look at the chat. There's a couple of questions there, but while you're having a look at it, Reghard, I'd like to go back to you. Before we get started, we were chatting about other forms of formalizing the areas of common property where these types of installations are done. Other than an exclusive use area, we looked at leases, and we know from a long-term lease perspective, and for a lease that's entered into with a non-owner or occupier of a section, a registered lease is needed. And then, of course, there's the option of servitudes. Could you perhaps just chat to us a bit about those registered abilities? And I suppose you could throw in registered exclusive use areas as well. So maybe a little bit about how that works. Where does it get registered? Where do you find it? I had the question earlier about servitude agreements. We very often have issues with when we know that there is a servitude registered, maybe between two bodies corporates for like access or something like that, and then nobody knows where the servitude agreement is. Willie also gave us some input in that, so I'll hand over to you.
Okay, thank you for the question. Yes, I think so. If we just start at the beginning, so I think we all know that the main right that any person would have in property is ownership, right? So in the sectional title context, you are the owner of your unit, which is basically the inside of your section, along with undivided share in the common property. But you don't. So that is the ownership that you have. The common property itself is owned by the body corporate. So you just have an undivided share in that as a member of the body corporate, obviously. So the question then is, what other rights can I have with respect to the common property? So if I want to use it for myself and not for everyone, especially if for certain legal or even insurance reasons, as we just saw, you need some kind of formality or some kind of structure in place for a different type of right. So you can't get ownership of part of the common property, but you can get a different type of right, which we call a limited real right. So a limited real right is basically a property right in property that belongs to someone else. So someone else is the owner of it, but you have a limited property right in that. And there's a couple of different forms in normal law, like kind of outside of sectional title context. The main example would be a servitude. So servitude just means a right that someone has over the property of another. Like the classic examples would be like a servitude road, for instance. But there can be many, many other types of examples where a certain portion of someone else's property is allocated to you and you have a right over it to do on it whatever the terms of the servitude dictates, whatever you agree to, for example. And that doesn't make you owner of that portion, but it gives you a strong property right to it. So such rights have to be registered in the deeds office. A related one, as you've mentioned, the exclusive use area in the sectional title context is, in a certain sense, a kind of servitude, really. We don't call it a servitude, but it's also a limited real right. It gives you the exclusive use of a portion of the common property, and that is a registered right. So you actually have a separate title deed for it. It's a notarial deed of cession. So some of you might have seen it when you buy property in a sectional title scheme and there's exclusive use area, they will give you two title deeds when you get your title deeds. So the one for the unit and one for the exclusive use area. That is if it is registered. So just on a side note, you can have a exclusive use area that is not registered, but that is included in the rules. So in that case, the rules of the scheme would even have like a little map that they attach to it, and they would say on the map, this portion here is an exclusive use area for unit 1, and this portion for unit 2, etc., etc. But that would not be registered in the deeds office, so you don't have a real right, a limited real right. In that case, you just have a personal right. So you don't have a property right, you just have a right to use that area in accordance with the rules of the body corporate. So it's more a right against the body corporate, and it's not a right to the property. But the effect is practically the effect will roughly be the same, except that you don't have a title deed for that type of exclusive use area. The rules is what tells you that you can use it. But yes, so in a case like that, I mean, as you mentioned, if this in the context of solar panels, this might be a useful tool to formalize your right to use the roof, for example. It may seem odd to have an exclusive use right with reference to your own roof, which is not really your own roof in a technical sense, but that could be a way to formalize it and to take care of a lot of future problems. If the owner knows in advance that they either have an exclusive use area over the roof, either personal right or real right, or even a servitude. I mean, it seems odd to register a servitude over a roof. I think for these type of situations, I think a servitude would be rare. I think an exclusive use area achieves the same purpose. So obviously there's a process that has to be followed to create new ones. Just to create it in a new scheme is much simpler than to create it later on in an existing scheme, because there's certain percentage of the owners have to agree. You know, it's going to be a process either way. But that is something that will at least formalize your rights to use it then. And of course, I think we've mentioned that if anyone wants to install things like this, always consult your body corporate. Never just go ahead and do it. And at the same time, body corporates should obviously also have good processes and rules in place to deal with this. I mean, I'm sure there are many out there that don't even think about it. People just go ahead and do what they want, and then later on, it's total chaos. So it's better to try to prevent these problems by putting things in place right from the start, communicating with everyone right from the start, and if necessary, make decisions on whether something like an exclusive use area will work for your situation or will work. And what type of solution will work best for your scheme? You know, getting proper legal advice, and even from people like Zerlinda and so on, what will work best for your scheme? Because not every type of solution will work best for everyone. It depends a lot on if is it a high-rise building, is it little houses, how does the roofs look? Some buildings might not even be suitable for solar panels. You see the horror stories of roofs collapsing. So all of those things must obviously also be taken into account. Just don't go ahead and do what you want to do. That's one of the things with sectional title, and Zerlinda mentioned right at the start that you own your sectional title unit, and yes, you have full ownership of it. It is recognized as a proper type of ownership. It's not less than ordinary houses. It's ownership, but at the same time, you are living in a unique setup where there's a bunch of owners living together in a community. You have to work together. Your freedoms are restricted to just do what you want to do. There are freedoms that an ordinary owner would have that will be restricted in the case of a sectional title. So you can't just do what you want to do. This is not, oh, it's my house, I can do what I want to do. Even in normal houses, it doesn't even really work like that. But especially in sectional title, you have to realize that you are living in a unique type of situation where your rights have to be balanced with everyone's rights, the body corporate's rights, the different owners' rights. So it is more tricky. The solutions are usually less or more complicated than what it would be in a normal standalone house. So take that into account and make sure that you communicate with your body corporate and that the body corporate has proper structures also in place to deal with managing this tricky kind of community setting of different owners living together.
Yeah, definitely. I remember Prof. Van der Walt always spoke about sectional title as being like a spin-off of neighbor law. So even in your freestanding properties, you still have to consider your neighbors. You still have to consider your building regulations. You know, you can't simply do whatever you want. A boundary wall or installing electric fencing on a boundary wall is a very good example. You can't simply say, okay, I'm going to break down the boundary wall or put 3 more panels up or put electric fencing there. It is something that you need to get your neighbors' consent on. So very, very interesting. The removal of the solar panels for me was like a huge eye opener. For many of you that have followed us for a long time, you'll know that I very often speak about how I came into sectional title and how my parents were always the ones in the sectional title schemes breaking the rules. My parents' last property in sectional title was where my dad was like, Jojo tanks, yes, I'll install 5 of them. Solar panels, yes, I'll install 15 of them without getting body corporate approval. Or I've got an extra car that doesn't fit on the driveway, I'm going to pave the parking bay next door. It doesn't work like that. You can't even say, oh, well, the neighbor did it, I'm going to simply do it because the neighbor did it. You do have to have those rules and things like that in place. Reghard, one last question for you before I hand over to Billy to wrap up for us, and then we can take a couple of questions, is how have you found, and I always find this fascinating, how have you found that what you deal with in practice influences, number 1, what you write about, and number 2, what you teach in academia?
Where do I start and where do I end? So it
2 minutes.
definitely impacts. I mean, when you work in practice, you do see things from a different perspective. You not necessarily even the things you encounter yourself directly, but your mind is kind of forced to shift in a different direction. You have to think about, and you see problems everywhere, and obviously you experience problems everywhere, and you realize that that things are never as simple as they look in textbooks. Not that the textbooks themselves are simple necessarily, but you always, especially when I teach, I always tell the students, it's not just a matter of, oh, the rule says this. That's the law, that's the answer, that's it. Or I just going to court, just get a court order. No, it doesn't work like that either. There's human dynamics. Most problems are actually about humans fighting about these things, not the technical rules about, and this in sectional titles. I mean, I didn't even have to say it. Most of the problems are not about the technical legal rules and of ownership and this and that. It's about someone is fighting with someone else, someone is mad at someone else, someone said something, the politics of it, the human element is something that you don't see if you just if you just work with textbooks. But so when I teach, I always try to convey, this is about trying to manage human relationships. It's trying to solve a problem, trying to negotiate a problem, not just running to court. No, we have to negotiate. We have to try to find a way to resolve the dispute. We can't go to court. It will take 5 years before we get a court date. It will cost so much money. It will not be worth it for anyone. So it's not just a matter of running to court. Oh, it's a principle. This principle is what the law says. That's it. No, you have to negotiate. You have to write very nice emails. You have to try and speak nicely to someone. You have to try and manage. And no, can't you just forgive this little problem now? It's dealing with humans. But yeah, I can go on rambling forever and ever on this. So let me just stop.
I feel like you're crushing these students' dreams. They all think they're going to go to court like suits and fight every single day, but it doesn't work like that. Most of the
If only, yeah.
outside of court. Billy, maybe you'd like to give some input on that, and then you can wrap up for us as well.
Thanks, Zerlinda. I've had a look at some of the comments, and there was just one thing that I wanted to add to one of the comments or questions that was posed. The question was, can the body corporate insure a rented solar system? And I think obviously you can insure everything in life. If you want to insure it, you can insure it. And if you want to give your money to an insurance company, be my guest. But the question is, would the insurance company pay out? That's a different question. And I think one must look at, I think where insurance starts is an insurable interest. So is there an insurable interest that the body corporate has in that solar system? And that will you will find the answer of that out of the decision that was made in respect of how to deal with the area where these systems were installed. So if it was, for example, a lease that you've rented out the roof space to the owner, and that contract then says that the owner is responsible for the upkeep, maintenance, and so forth, then obviously there won't be an insurable interest. If it's common property and it's an exclusive use area, then there might be one. So it's also not a easy question. So one must actually go and have a look at your agreement, at the agreement with the person that rented it out or sold it or leased it. And then also with the body corporate as to what the space is that is being utilized in that regard, and then to determine if there's an insurable interest. So that is, I think, what one should, from a legal point of view, do. Practice, obviously, as Reghard said and Mike says, is completely different. So if your insurance company is happy to do it like that and they will pay out, then no problem. But just from a legal point of view, make sure that you are on the right side of the law in that regard. So yeah, so a very interesting subject, and thanks for the opportunity. I think that's me.
Of
I
course.
don't know if there's anything else that I can contribute now.
Willie, could you maybe give us some input on how the courts are working at the moment? I know Reghard made the comments about, if you want to go to court, you're going to get a court date in 5 years. And I've been talking to a lot of clients at the last while, and I've seen, and I can't remember if it was you or one of our other colleagues that mentioned, the timelines of court at the moment, the semi-urgent role, the urgent role, and all those fun things. And when I tell clients, look, the semi-urgent role, you're looking at a date at the end of next year type of thing, at least in the Western Cape, they're sort of like, oof, okay, I need to resolve this some other way type of thing. What has your experience been with the courts, especially with courts online? I know you guys have quite a working system now in Johannesburg. Cape Town's a little bit lagging, but just to give us some input on that.
Sure. So obviously, there are two ways that you can approach a court, action or application. Application is on paper, so you file affidavits. That process is used where there's no dispute of fact and where you only are fighting about the legal principle. So therefore, the court would not require witnesses to testify. The court will make the ruling on the papers in front of the court. So that process is quicker, obviously a quicker process, because you don't have to get a court date where the courts are going to sit days listening to witnesses and cross-examination and so forth. So prior to COVID, matters went through the courts very quickly. An application would be heard within 2 months to 3 months. An urgent application could be heard in 2 to 3 weeks. Subsequent to COVID, that periods actually became much longer. And a normal application would go for a period of about 8 months, 9 months to 12 months. Urgent applications 2 to 3 months before the urgent application is heard. And then actions where the court, where a summons is issued and a plea is filed and go through that whole process. The court dates that were allocated. We got dates this year, in the beginning of this year, we got dates for 2031 for actions. But the Department of Justice has taken that on, and they have tried to actually bring mechanisms in to actually shorten the period. So dates were removed and people were now ordered to actually sit around the table and see if they can't settle those matters. And then there was no settlement coming out of that. Then new dates were allocated. Also, specialized courts were now made, for example, liquidation courts. So there's also quicker dates for liquidation courts and sequestration courts. So yes, we are seeing that the dates are becoming better, and we are now seeing applications being heard within about 4 to 6 months. So things are improving, and hopefully in respect of the actions, we'll also see better dates, hopefully within the next year or 2 years, and not 5 years and 6 years.
Sure. When Reghard said 5 years, I was like, oh, a little bit long, but 2031, that's insane. Absolutely insane. Thank you so much, guys, for your participation. I know that Mike has been frantically busy answering questions on the chat. Thank you so much. Before we close off, any concluding remarks, Mike?
No, that's it.
You're all
Thank
good?
you.
Thanks so much. And
All good.
Not really anything from my side, but yeah, thanks for the day. It was fun to speak a little bit about these things.
Awesome. Fantastic stuff. Willie, thank you so much for your time. Thanks, guys, for your time. For everyone that attended, thank you so much. Carl, are we having another webinar this year? Was this our last one for the year? I feel like it was our last one for the year, not so?
We have one coming in December.
One more coming in December. Fantastic. Thank you for joining us. We'll see you in our next one. Don't forget to join our neighborhood. We've got both a free platform as well as paid for, so you're more than welcome to hop on there to see what it's like. And for our neighbors that correspond with us and meet us and all those fun things, thank you very much. Please go and check out Mike's website, Reghard's website, Willie's website. Willie has got an amazing 12-module free trustee training course. And Reghard, I'm sure on your website, and if anybody had to Google you, they'd be able to find your master's and doctorate and all the interesting writings that you do. So perhaps just pop those links through to Carl, and he will share it with the recording on our website in early next week, I believe. It'll be very interesting to see more about what you do. And then, of course, we all know that Addsure has YouTube links. I don't think that there's one question that Mike and his team don't have a video or a blog post for. So thank you so much, Mike, for always sharing that. That's easily available as well. Until next time, everyone, have a great day further and a good weekend coming up, and we'll see you next time. Keep well. Bye-bye.